And it is now time for our legal desk. And we're still on labor law, employment law, if you may. And all through last week or the last couple of weeks, we've talked about the rights and obligations of both parties. Last week, we rounded up on the rights of both parties under the agreement, the collective agreement. And today, we're going to go into the obligations of the employer under common law. And before we start, of course, to help me go into this is our ever-present in-house legal expert, lawyer Samoa, who's not going to court today, so I've got him for some time.
Sure.
Good morning.
Good morning, Sandra.
How are you doing?
Fine.
How was the weekend?
Relatively cool.
Okay, all right. So let's delve straight into this. Now, today we're talking about the obligations under common law.
That is so.
I think we brushed over the obligations under the Act last week,
Yes.
But
it would be appropriate to just recap.
Do a quick recap. Okay, can we do that?
We said that the obligations of the parties, particularly the employer, is defined under many sections. We have the first level under the contract of employment. That is that when the worker was engaged, the contract of appointment had some obligations of the parties. That is one. Then we have the obligations under the collective agreement. Collective agreement is agreement reached with the employer after the worker had been employed. It's normally done by the trade union, okay, or the workers' union. They come together and say that these are the things. And we said that normally the collective agreement would overshadow any other term in the contract of employment itself.
Right.
And then we have certain obligations under the Act and certain obligations under what we call the common law.
Okay, so what we discussed was basically the rights and obligations under created by Parliament when we talked about the Act.
Yes.
But today we're going to talk about under common law, which is over the years courts made law and all of that. So, take us through that, please.
All right, there are a number of obligations found under the common law, which are, like you said, these are judgments of courts. The courts have gone through cases and come out with these principles, and it has become law as it were. We have the first one is the obligation of the employer to provide work for the worker, and then to provide safety for the safety of the worker is also to provide safe system and then provide adequate tools for the worker.
Okay, so the first one is to provide work.
Yeah, that's so.
And that would seem very basic, wouldn't it?
Well, it should be that, of course.
You provide work for your employee.
If you employ somebody, it's because you had work that somebody else should do. That's why you got it. So, but the question is, can the worker compel the employer to give him work?
Okay.
Yes, but the law says that the worker hasn't got that right.
You can't compel your employer to give you work.
Yes. He has engaged you that come and work for me.
Okay.
If he has got work, he gives you.
So if he hasn't got work,
well, then you be there. But come on,
so can you stay home if there's no work?
No. It has been decided in some cases, particularly state hotels corporation and also a free, that the worker cannot stay home only because the employer has told him that I don't have work today or tomorrow. Remember?
But if there's no work, why go to work?
But the first thing is that why are you a worker?
You're there to work.
You are a worker because somebody has decided to book a particular period of your life, some hours.
Right.
Okay, maybe 8 o'clock to 5 o'clock.
Oh,
He's paying you for it.
Okay.
So he can ask you to come to work and sit down and just look at his face.
Right.
And you don't have the right to compel him that
give me something to do.
Yes. Or alternatively that if you don't give me anything, then I won't come.
Wow.
In fact, in that case, the worker was held that he was liable because eventually it's like you have dismissed yourself for not reporting to work only because the employer says that he's not going to work. You must come and demand your pay accordingly.
Even if you don't render any work.
Exactly. And that's the other side of it, that whether the worker works or not, if the worker reports himself to work and the employer hasn't got work to do, or the work is not able to carry him the whole day, the employee, that's the worker, is still entitled to be paid for the whole period that he has come to work.
Wow, that's a very interesting one. Okay, let's move on now to the next one, to provide for the safety of the worker.
Exactly. Now, it's the obligation of the employer, that's the boss, to make sure that the place of employment is safe for the worker. It's very, very important, and it combines a lot of legal principles, particularly in the area of what's called negligence, law of negligence. That is so that if you admit a person to a premises, for instance, like the worker, they must make sure that the environment in which you are admitting the worker must be safe, and so that there should be no hazard, there should be no harm to the worker as he comes to work or where the place is supposed to work.
So basically, the employer must take reasonable care to ensure that the workplace is safe.
It's safe for the worker. Yes, it's safe for the worker, and that is in negligence. And the law is that you must take reasonable care. That is to that do what a reasonable man would do in the circumstances. In the circumstances is that once you have asked somebody to come to work in an environment make sure that the environment is safe. We are talking about things like pollution, make sure don't expose the worker to maybe fire, etc. Things that will affect his health and make him sick, etc. You should know. And it is the duty of the employer to make sure that the place that the worker is working is safe for him.
Okay. So can you tell us some of the things that the worker can, provide to make the place, maybe competent staff?
Yes. There
provide you
like
the
that.
necessary materials
Exactly,
that you need.
exactly. There are some kind of work, and it will tie up to the next one. There are some kind of works. For instance, have you noticed those who do what you call electric welding?
Yes, the welders.
You
yes,
see
I've
the
seen
kind of
welders.
spark that comes
Right,
out of the
and
weld.
they weld these goggles
They are
and all those.
supposed to wear.
Oh, I think I've seen them wear.
You don't tell me to.
Not all of them wear it?
Some of them will hang it on their head and they use their naked eye.
Oh, so it's been provided, but they are not wearing
But
it.
then
But in this case, is the employer liable?
Yes, because it is the obligation of the employer to supervise the worker to ensure that he is safe. So that if the worker even himself is exposing himself to danger, it is the obligation of the employer to ensure that the worker
So
is
effective supervision also counts.
It's very important.
Okay.
It's very important.
Wow. All right, so let's go to the third one then.
Yes, and that ties into the third one is to provide safe system of work. Safe system of work it means that the employer must devise a system that is safe for the worker, and then it also means that he must, through effective supervision, ensure that the employee does what he's supposed to do.
What cases where the employee is experienced, then do they still need supervision?
Yes. Because there's something in law. If you don't supervise him, and then there's an injury, it's the employer that will be held liable. Okay.
Even if I'm a full-blown
Exactly.
professional, I'm
Yes,
qualified, I'm very
yes.
experienced, I
Yes.
still need someone looking over my shoulder?
Exactly. In this case, I'm talking about somewhere far in campus. One of our lecturers asked that a company should dismiss a particular worker. Why? Because he went to the place and then the safe gadgets, for instance, the goggles that they are supposed to wear, he decides not to wear it. And then he asked that employer should be dismissed. Because it is the duty of the employee be dismissed, because the duty of the employer to supervise the employee to ensure that they do what they must do in order to be safe.
Wow. Okay. So basically just provide...
some workers are simply negligent, they are reckless, okay,
Yeah.
they don't care. But when we stretch this matter very far, you know where it will end? It will end as a liability for the employer.
Okay. So they're liable if they don't see to it that.
For instance, the person that was dismissed for not putting up the necessary eyewear. You realize that after some years, maybe 10, 20 years, and then all that you see is that he goes to complain about his eye. He says, I'm going blind because I work in this company. And there, when the company is hauled to court, the company will not be able to defend itself. It will be as though the company didn't provide the safe work materials.
What about providing competent work?
Yes, it's also an obligation in common law that the employer should provide other workers who are competent and fit, and who are equally good in order to do the work.
What is the effect of not providing such people?
There's something in law, we call it vicarious liability. We'll discuss it under this one. This is where an employer is held liable for the negligence of a worker. So that here we have a worker who is not supposed to do something and he does it. That employer, a co-worker, will not be held answerable because the employer did not do what he must do. For instance, there's something that a co-worker must do, maybe an equipment he must pick, and he doesn't do it for the other party.
That's going to bring me to my next question, actually, and we've almost run out of time. So just quickly tell me about providing adequate and the right equipment on the job.
Basically, the employer must provide the tools for work. It is not for the employee to carry tools from his house and come and do the work of the employer. Okay, for instance, if you employ people as mechanics or in the mines or in factory, you don't expect them to bring their various screwdrivers and spanners to come in. You must provide, and you must provide good ones, because if they use them and they run into problem, then you, the employer, will be held liable in law.
Okay,
these are the obligations.
I think there are a lot more duties of the employer contained in the act itself.
Yes. Actually, the act just repeats most of these ones and just added a little few. And
all right, that's all the time we have today, unfortunately. So tomorrow we'll talk about the rights of the worker,
yes, we'll not concentrate
which is also
on the worker.
contained in Act 651.
Exactly,
okay, so we'll
and the common law as well.
Tomorrow. Thank you so much for your time. I know you have to go to court, so it's really good. Thank you very much.
Right.
This has been the Legal Desk with lawyer Asamoah. And join us same time tomorrow. Do stay with us.